Well, good afternoon, folks. I am Misha Janice. I'm an attorney here in Florida and New York, and I've been covering the Justice for Dan Markel um, murder trial and the saga that has been going on for 10 years now, over 10 years now. Um, there have been a lot of developments in that case, and I wanted to bring you the latest development that I was able to find. I just took a break from the Sarah Boone case, checking the appellate docket for Charlie Adelson, who was convicted of of murder, his part in the hit murder of his former brother-in-law Dan Markel. So we heard a few nights ago, I think it was, that this motion was going to be filed, and I've been checking it, and I was able to just find it uploaded to the appellate courts. So I haven't gone through it yet. So I figured as long as I'm going through it, I might as well take you guys along for the ride. So that's what we're going to do. Now, I have just maybe a little bit more than an hour until I have to go pick my child up. So I'm going to try and get through this as fast as I can. This document is 18 pages, but there's it looks like a lot of quoted text in here and quoted case law. So let's get right into this. Make sure you say hello in the comments. I'll stop periodically to check the comments and just see if everything is going right. If you can hear me, could you put a 1 in the comments? Let me just check my audio really quick. Just want to make sure before getting into the meat of the matter. I think this should be good. Y'all. All right. Oh, hi, Marie James. Hi, hey. Marie was also in my chat earlier covering Sarah Boone's opening statements. I had to take a break from that. So thanks for coming back here. Nice to see you. All right, let's get right into this because I don't have a ton of time. Hey, Marcus, I have to give you a shout out as well. You're always following, always supporting. Appreciate that. All right. So this is Charles Adelson versus the state of Florida. This is the motion to relinquish jurisdiction to the trial court. This is what was filed in the appellate court where his case is currently pending. Now, it's been pending since early this summer, and earlier this summer, actually, which is when his appellate brief was first supposed to be filed, they've gotten multiple extensions for that, and now the initial appellant brief was supposed to have been filed today, October 18th. Instead, we see that this motion that we're looking at right now was filed 2 days ago in place of that appellate brief, and we're going to find out why. The appellant, Charles Adelson, by and through undersigned counsel, moves the appellate court, to relinquish jurisdiction, in this case, to the trial court, that's where Judge Everett is, and alleges the following. Appellant Adelson is appealing his convictions following a jury trial of murder, conspiracy to commit murder, and solicitation to murder. Appellant Adelson was sentenced to life in prison. Appellant Adelson is one of several persons charged with the murder of Dan Markel. Prior to Appellant Adelson's trial, 3 other people were convicted of the murder of Mr. Markel: Sigfredo Garcia, Luis Rivera, and Catherine Mignanoa. After Appellant Adelson's trial, but before his sentencing, another alleged co-conspirator, Donna Adelson, Appellant Adelson's mother, was indicted and arrested for murder. So this is just getting a brief background of all the things that have gone on in the past couple years. At his trial, Appellant Adelson was represented by attorney Daniel Rashbaum, Esquire. After Appellant Adelson's sentencing, Mr. Rashbaum appeared as counsel of record for Donna Adelson in her case. On September 11, 2024, the state issued a subpoena on Appellant Adelson for him to be a state witness at Donna Adelson's upcoming trial. Shortly thereafter, on September 17, 2024, Mr. Rashbaum withdrew from Donna Adelson's case after the trial court, the Honorable Stephen Everett. Footnote 1, Judge Everett also presided over Appellant Adelson's trial. Back to the text, questioned him about the conflict of interest that existed due to his current representation of Donna Adelson and his previous representation of Appellant Adelson, who was now a witness in Donna Adelson's trial. So messy, right? Then on October 7, 2024, the trial court disqualified Donna Adelson's other defense lawyers from her case on the basis of Mr. Rashbaum's conflict of interest. Quote, the withdrawal of attorney Daniel Rashbaum became necessary when he engaged in a conflicted representation falling short of the ethical obligations for members of the Florida bar. Those scathing words, right, from Judge Everett's opinion. Upon further consideration of the September 17, 2024 record and the in-camera proceedings with attorneys Daniel Rashbaum and Robert A. Morris, a sufficient ethical wall was not established. Thus, the conflict of interest involving privileged information or communications has been imputed to Robert A. Morris. It's kind of like Rashbaum's stank got on Morris, right? Additionally, this case is, quote, rife with the potential, close quote, for the same conflict as to Adam Commissar. That was the young guy who appeared at the hearing and supposedly gave Donna a conflict session with an uninterested attorney, basically. Quoting some cases, some precedential cases, which I will skip over. Florida rules of regulating the Florida bar. Those sections impose on all Florida attorneys an ethical responsibility to refrain from engaging in conduct intended to disrupt a tribunal and conduct which is prejudicial to the administration of justice. While the defendant retains a presumptive right under the Sixth Amendment to her counsel of choice, the right is not absolute. The presumptive right under the Sixth Amendment to counsel of choice cannot interfere with the fair and orderly administration of justice or the court's authority to monitor and control the pace of litigation. Both federal and state courts have repeatedly made clear that the right to counsel cannot be manipulated so as to obstruct the orderly procedure in the courts or to interfere with the fair administration of justice. This is when Judge Everett was putting his foot down and saying, we're not going to deal with this anymore. You guys are just stringing us along. It's just causing too many disturbances right now. So he cut all ties, basically. Went on to quote several cases of precedents. Goes on to say the fair and orderly administration of justice cannot be maintained when conflicted counsel or counsel with the potential of conflict cannot meet the standard of serving as constitutionally effective counsel. I'm not going to read all the citations, you guys, because there's going to be a lot more of them further along, and we don't have all day, right? Furthermore, the danger to conflict-free proceedings was not cured by Daniel Rashbaum's withdrawal. Prior to the selection of the jury, Charles Adelson filed a notice indicating his non-waiver of any conflict of interest with Daniel Rashbaum. Robert A. Morris then filed a response in which he advised that third-party counsel had been retained to resolve any actual or potential conflict of interest. In a reply to this response, Charles Adelson objected to Morris or a third-party counsel cross-examining him. The third DCA, when reviewing the disqualification of counsel in Colker, disagreed with the proposition that an, quote, actual or potential conflict could be avoided by having substitute counsel conduct the cross-examination of a former client. The Colker court further explained the conflict arises from the past relationship, right? And we know that relationship with the Adelsons, the parents Adelsons, Donna and Harvey and Rashbaum, goes deep. And it cannot be avoided by sectioning off portions of the trial, which is what they were trying to do with bringing in Adam Commissar. The potential for conflict would remain, as would the appearance of impropriety. Absent judicial intervention at this point, delay to the fair and orderly administration of justice will be at risk of repeating itself. Without the establishment of a sufficient ethical wall, and the fact that even third-party counsel cannot avoid the potential for conflict, the court cannot permit Robert A. Morris or Adam Commissar to remain as counsel of record, nor will the court permit this untenable situation to continue. Accordingly, for the above reasons, attorneys Robert A. Morris and Adam Commissar are disqualified from further representation of the defendant. So that was the text of the order from Judge Everett. Moving on. Against this backdrop, undersigned counsel believed that Mr. Rashbaum's conflict of interest also infected Appellant Adelson's trial. So that's Charlie's trial. During the course of their representation of Appellant Adelson, undersigned counsel, that's who's writing this, Ufferman, learned that Mr. Rashbaum represented Donna Adelson prior to the arrest of Charlie Adelson. Stated another way, Mr. Rashbaum previously represented a co-conspirator, Donna, in the same or substantially related matter, and he had an actual conflict of interest during the course of his representation of Appellant Adelson. Let me repeat that again. Rashbaum had an actual conflict of interest during the course of his representation of Charlie, Appellant Adelson. That's the problem that they're pointing out right now to the appellate court. 6. Notably, Donna Adelson was listed by the state as a Category A witness in Charlie Adelson's case. Subsequently, Donna Adelson was listed as a defense witness for the trial. Ultimately, Donna Adelson was not presented as a witness during Appellant Adelson's trial. I'm going to call him Charlie Adelson because I don't want to get the names mixed up, okay? So ultimately, Donna Adelson was not presented as a witness during Charlie's trial because she was removed from the defense witness list days before trial was to begin. After the state sought to interview her, undersigned counsel, Ufferman, asserts that Donna Adelson's removal from the witness list was done in order to protect Donna Adelson's interests, i.e., in not being interviewed by the state. And not only that, it was against Charlie Adelson's interests, in that a witness that could have corroborated his testimony, Charlie's testimony, was not called by Daniel Rashbaum. Hence, Mr. Rashbaum's representation of Charlie Adelson at trial, after having previously represented Donna Adelson, constituted an actual conflict of interest. Let's read the rule real quick. It's in a footnote, Rule 4-1.9 of the rules regulating the Florida Bar, entitled Conflict of Interest. Former client states the following: a lawyer who has formerly represented a client in a matter must not afterwards, A, represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent. B, they must not use information relating to the representation to the disadvantage of the former client, except as these rules will permit or require with respect to a client, or when the information has become generally known. Or C, they must not reveal information relating to the representation, except as these rules would permit or require with respect to a client. I think they're going to get more into this definition, so I won't expound on that right now. Let's go back to where we were. As explained by the 11th Circuit Court of Appeals in Porter versus Singletary, an attorney who cross-examines a former client, like Rashbaum cross-examining Donna, inherently encounters divided loyalties. Given the recent finding by the trial court in Donna Adelson's case regarding Mr. Rashbaum, quote, engaging in a conflicted representation, falling short of the ethical obligations for members of the Florida Bar, close quote, Charlie Adelson asserts that the same principle applies to Mr. Rashbaum's representation of Charlie Adelson at his trial, because attorney Rashbaum was operating under a conflict of interest based on duties owed to his former client, Donna, whose attorney-client relationship predated Charlie's. Documents supporting the statements set forth in the previous paragraph are included in the appendix to the motion, and the documents establish the following. The murder of Dan Markel occurred in July 2014. In 2016, the probable cause affidavit naming Sigfredo Garcia, Luis Rivera, Catherine Mabanoa, Appellant Adelson, Charlie, and Donna Adelson as co-conspirators was released. In 2016, Daniel Rashbaum was Donna's attorney for purposes of the investigation into the murder of Dan Markel, as evidenced by his signature on the, quote, Adelson family statement. In 2022, Appellant Adelson, Charlie, was charged with the murder of Mr. Markel. Mr. Rashbaum filed a notice of appearance on May 9th, 2022. Appellant Adelson, Charlie, did not validly waive the conflict of interest involving Mr. Rashbaum's representation of him at trial and Mr. Rashbaum's prior representation of Donna Adelson, who was listed as a witness by both the state and the defense. A review of the record on appeal establishes that a conflict waiver inquiry was not conducted by the court. So, yeah, I don't think anybody remembers Judge Everett asking specifically about that particular conflict, right? He asked multiple times. He asked Donna multiple times. But in Charlie's trial, I don't recall him ever having asked Charlie if Charlie waived any conflict due to Rashbaum's prior representation of his mother, Donna. Let's see. In Lee versus State, this court articulated the requirements of a valid waiver to the right to conflict-free counsel. For a waiver of conflict-free counsel to be valid, the record must show that the defendant was aware of the conflict of interest, that the defendant realized the conflict could affect the defense, and that the defendant knew of the right to obtain other counsel. Let me go back to this bulleted list. This is the list of the stuff that that is set forth in, I guess, documents attached to this motion. These are all facts that I think we all know. On September 22nd, 2023, Donna Adelson, Mr. Rashbaum's former client, was listed as a state witness for Appellant Adelson's trial, for Charlie's trial. Also on September 22nd, 2023, Donna was listed as a witness for the defense for Charlie's trial. In October 2023, Mr. Rashbaum withdrew Donna Adelson from the defense witness list in Charlie's case after a hearing in which the state sought to compel Donna's interview. So the state was like, we want to interview you, Donna. And Rashbaum was like, actually, no. We'll just take her off. You don't have to interview her. No. She doesn't want to talk to you. In October to November 2023, Charlie was tried and convicted while represented by Mr. Rashbaum. In November 2023, Donna Adelson was indicted and arrested for the murder of Mr. Markel. In a November 2023 recorded conversation leading to Donna's arrest, Donna discussed advice she had received from Mr. Rashbaum regarding whether she would be able to leave the country undetected prior to being arrested for the murder of Mr. Markel. Quote, look, we have to make a decision at some point. After speaking to Dan this morning and knowing what they're thinking up there, I don't know if we'll make it out in time. I really don't, because Dan said you might do all of this, get to the airport, and they'll stop us. And that could happen. It could happen. I don't know, but it's worth a try. In December 2023, Appellant Adelson, Charlie, represented by Mr. Rashbaum, was sentenced. In January 2024, Mr. Rashbaum appeared as Donna Adelson's defense counsel for trial. In September 2024, Charlie was subpoenaed as a witness for the state for Donna Adelson's trial. In September 2024, Mr. Rashbaum withdrew and or was removed, the shade, from Donna's case by the trial court on the eve of jury selection on the basis of Mr. Rashbaum's conflict with Charlie. In October 2024, the trial court, on its own motion, removed the remaining defense counsel for Donna on the basis of Mr. Rashbaum's conflict of interest and the lack of a sufficient ethical wall. Accordingly, in light of the foregoing, Charlie intends to file a motion in the trial court raising this conflict claim against Mr. Rashbaum, who represented Charlie at trial while owing duties to his former client, alleged co-conspirator and listed witness, Donna Adelson, to whom he continued to provide legal advice regarding her own involvement in this case while simultaneously representing Charlie. Because Mr. Rashbaum's conflict of interest in Donna Adelson's case was just recently considered and ruled upon by the trial court, undersigned counsel, Ufferman, submit that it would be in the interest of judicial economy to allow the trial court the opportunity to immediately consider whether the same conflict infected Charlie's case. The trial court is uniquely situated to decide this issue, having previously presided over Charlie's trial and now presiding over Donna's trial, and because the trial court was recently apprised of the conflict issues involved with these lawyers and parties. Charlie therefore requests the court to relinquish jurisdiction to the trial court for a reasonable period of time so that he, Charlie, can file a motion raising this conflict issue. Charlie respectfully suggests that it would be a more efficient use of judicial resources to address this matter immediately, because if the trial court grants the motion, then the instant appeal will become moot. Meaning, if Judge Everett says there was a conflict, your conviction is overturned, let's get you a new trial, Charlie, then Charlie won't need to appeal the conviction that he already has, okay? In State versus Meneses, the Florida Supreme Court considered the question of, quote, whether the pendency of a petition for writ of certiorari in the Florida Supreme Court arising from the affirmance on direct appeal of the judgment and sentence deprives the trial court of jurisdiction to consider a Florida Rule of Criminal Procedure 3.850 motion to vacate filed after the certiorari petition has been filed in the Florida Supreme Court. What does that mean? This case just talked about whether the fact that there's an appeal pending means that the appellant can't go back down to the trial court to ask them questions, basically. The Florida Supreme Court held that the trial court was deprived of jurisdiction. So the trial court has washed its hands of Charlie Adelson. Charlie Adelson technically is now the problem of the appellate court. So that's why he has to ask the appellate court if you'll release me so I can go back down to the trial court and ask the trial court to look at this conflict issue. All right, so the Florida Supreme Court held that the trial court was deprived of jurisdiction to rule on Meneses' motion to vacate while certiorari proceedings were pending in the Florida Supreme Court. However, at the conclusion of the opinion, the Florida Supreme Court stated the following: our holding, however, does not preclude defendants seeking an order from the appellate court to temporarily relinquish jurisdiction to the trial court for the purpose of filing and being heard on a motion to vacate prior to the appellate court's disposition of the case. And that is what Charlie's attorneys are seeking to get right now. They're seeking to go to the trial court to be heard on a motion to vacate his conviction due to this conflict issue. This is the practice now utilized in the appellate courts in the state. The filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. So the appellate court does need to rule on this. The proceedings in the appellate court may be nearing conclusion, which is not the case here. It hasn't even started in Charlie's appellate case. And therefore, the appellate court may not wish to relinquish jurisdiction at the time of the request, but it might prefer to proceed with the disposition of the cause. This is within the discretion of the appellate court to decide. Further, the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide not to relinquish on this basis. This denial of the request to relinquish, however, is not a ruling on the merits of the motion to vacate and will not prevent a subsequent filing of a motion to vacate with the trial court at the conclusion of the proceedings in the appellate court. So the remedy suggested in Meneses was followed by this court, the appellate court that Charlie's in Jefferson versus State. In Jefferson, while the defendant's direct appeal was pending, the court, quote, entered an order temporarily relinquishing jurisdiction so that the defendant could pursue a Rule 3.850 motion. The court stated that the following procedure applies when such relinquishment is granted. And they quoted another case. So this is a Florida Supreme Court case from 1981, authorizes relinquishment of jurisdiction to the trial court when counsel informs the appellate court of an honest belief that there is an issue as to ineffective assistance of counsel. That opinion, as well as State versus Meneses, appears to us to contemplate that the proper procedure to follow when such relinquishment is granted is to file a motion for post-conviction relief pursuant to Florida Rule of Criminal Procedure 3.850. If the trial court does not grant the relief, a new notice of appeal may be filed. The original appeal may proceed if there are other issues and should be dismissed if there are not. As our order in this case stated, jurisdiction was relinquished for collateral proceedings, such as instituting proceedings separate from the trial and pending appeal. However, no such motion was filed. Instead, the trial court and the parties apparently relied on the allegations in appellant's motion to relinquish. While this procedure was not in technical compliance with our order, we entertained the appeal by treating the proceedings below as having been conducted pursuant to the remand for hearing upon an application for new trial. I don't really feel like he had to put all this in, but it's not my motion, right? See Anton versus State, cited in Combs, in which the Supreme Court remanded for testimony in the trial court on application for new trial. Under Florida Rule of Criminal Procedure 3.600B8, ineffective assistance of counsel may properly be raised as a ground for new trial. The issue in this case, having been thoroughly aired before the trial court, it is now sufficiently preserved and presented for our review, and the appeal from the judgment of conviction is carried over for that purpose. What is all that? This is all cases supporting what Charlie wants to happen, right? It's all cases laying out what these other people did in their cases when there was an issue, maybe at the trial court level, citing ineffective assistance of counsel, which is what Charlie is trying to do. So they're just going through precedential cases where it's been determined that something needs to happen to release the appellant from the appellate court and go back down to the trial court. And they're just kind of going through the procedure of how that's done. See also Libby versus State. Accordingly, we affirm the trial court's denial of appellant's Rule 3.850 motion without prejudice to appellant. 1, filing another such motion after his present appeal has been decided and has become final, or 2, as recognized in Meneses, seeking an order from this court to temporarily relinquish jurisdiction, which is what Charlie's asking for, to the trial court for the purpose of being heard on his motion. The Rule 3.850 proceeding was conducted in the trial court while the plenary appeal was pending here, pursuant to our express relinquishment of jurisdiction for that purpose. Have a sip of water. Let's stay hydrated. Let me check the comments real quick. Let's see what you are saying. Let's see. Jen Still, hello. I live in Pittsburgh, Pennsylvania, and work in marketing. And I could see the conflict so frustrating. Yeah, girl, we could all see the conflict. They should just arrest them all and have one trial. Yeah, that would be a lot of judicial economy, wouldn't it? Hi, Cheryl B. Hey, Trish, Norman. But both Donna and Charlie knew and used Rash to communicate when Charlie was in jail. Yeah, Rash was working overtime, seriously, and it wasn't ethical, allegedly. In my opinion, they thought it was advantageous because they were co-conspirators, not that Charlie is convicted. It's a problem. Sure is a problem. Hi, Tanika. Hey, you guys. Make sure you're subscribed to Tanika's 2 cents. We are doing another live stream tonight regarding this Sarah Boone trial. Looking at some of the witnesses over there in that trial, which actually finally got started today. So I streamed the opening statements, and we'll probably, I imagine, go over some of that later tonight, right, Tanika? But thanks for being here. Hey, Judy. This is Judy with AA Legal Focus. Also, make sure you're subscribed to her. I'm sure you are, you guys. Like, Judy is an OG in the Dan Markel space community. Thanks, Judy. Thank you for joining. Hello, Maya Rodriguez Sorensen Esquire. Hello, so glad you're reviewing this. I'm working and lurking, but it's it's Friday, so I'm going to chat too. Work and lurk. That's what we do over here. That's what we do over here. Hopefully, some big things in our future together. We'll see. Fingers crossed. Gossip Rumor and Independent Channel has talked about Tanika's 2 cents. I'll have to subscribe. Yes, absolutely. That's a great channel too. She is hilarious. She is very funny with her recaps. Love Kathy over there. All right, let's get back to this because it is 4:06. Okay, more recently, this court followed the relinquishment procedure set forth above in Ferguson versus State, as demonstrated by the court's December 30th, 2020 order in that case. Footnote 6, notably in Ferguson, the trial court granted relief after this court, the appellate court, relinquished jurisdiction, and therefore the direct appeal in this court, the appellate court, was later voluntarily dismissed. That's exactly what Charlie wants. Cases being cited: Hatton versus State, Crane versus State, Cugini versus State. Pursuant to menaces Jefferson, Ferguson, and Libby, appellant Adelson, Charlie, requests the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict claim. Consideration of the factors set forth in Meneses and Jefferson establishes that relinquishment is appropriate in the instant case, i.e., the current direct appeal proceedings are not, quote, nearing conclusion, close quote, as the initial brief has not yet been filed. That's what I was saying. The initial brief was originally due, I think, earlier this summer, and they've gotten maybe 3 or 4 extensions at this point. Charlie Adelson's conflict claim is not, quote, frivolous, and the undersigned counsel have an honest belief that there is a credible and good faith basis for Charlie's claim. Moreover, Charlie submits that it serves both the interest of justice and judicial economy by having the trial court address Charlie's claim at this time, since the conflict claim was just considered by the trial court in Donna Adelson's case. Footnote 7. Florida Rule of Appellate Procedure 9.600B states that if the jurisdiction of the lower tribunal has been divested by an appeal from a final order, the court by order may permit the lower tribunal to proceed with specifically stated matters during the pendency of the appeal. The rule is intended to prevent unnecessary delays in the resolution of disputes. And Lord knows that that is exactly what we need here in this case. We need unnecessary delays in all the disputes in this case to be prevented. Certificate of counsel. Undersigned counsel have contacted opposing counsel, Chief Assistant Attorney General Tricia Meggs, Pate, who has indicated that the state needs additional time to consider its position. Undersigned counsel will file a supplement indicating the state's position, or the state will file a response. So the state representing the state of Florida in this appeal is represented by Tricia Meggs, who I have come to learn is the daughter or relative of Mr. Meggs, Willie Meggs, I believe the name was. who was probably solely responsible for the lack of prosecution in this case for years and years and years. I don't know much about the relationship between the two of them. I don't know. Do I smell some nepotism? Possibly, but I really don't know about it, so I can't speak on it beyond speculation. But I find that strange. I find that funny, and we've seen her name come up multiple times already. In this case, each time Charlie has sought an extension of time to file to file his initial brief. Wherefore, the reasons set forth above, Charlie Adelson, the appellant, requests the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict of interest claim. So that is the motion. That is the motion that caused the huge stir this week, finally getting to read it on Friday, 2 days after it was filed with the appellate court, apparently. So, does anybody have thoughts? Does anybody have thoughts? I mean, look, as much as we don't like Charlie, he may have a point here. There may be a point here, and it's bolstered by Judge Everett's ruling, the latest order, in which he said Rashbaum, acted unethically in his representation of the Adelsons. So, absolutely, Ufferman is doing his job. He is, zealously representing his client. He's doing everything that he can to work for his client. He's doing a really good job, although we hate them. Hate's a strong word. Although we really don't like the Adelsons, Ufferman, I have to say, he's doing the work, because this is exactly what an attorney should be doing, looking for these reasons. And this reason kind of was, offered up on a silver plate for him, especially after the debacle that happened a couple weeks ago at Donna's pre-trial hearing. So that's it. That's it. We'll see where this goes. I don't know the timing. Let me see. I guess I would have to look up the timing for a response. I feel like most of the time a response is due, in 30 days, but I don't know when a response would be due by the state. They're going to have to respond to this. And apparently, Ufferman asked for a response because he let them know that it was going to be filed, and the state said that they needed additional time to consider its position. So that's where we're at right now. That's where we're at right now. Let's see, questions. Trish, yeah. I hate this for the Markel family as well. It's just like more uncertainty, right? They thought that small chapter was closed, at least to the extent of, having a conviction on the books, a conviction of somebody with the last name Adelson, and now it's possible that it gets overturned. It is possible. Sorry, is he asking, Marie James is asking, is he asking for a new trial or new sentencing? If he gets a new trial, wouldn't he have to use the same defense? So ultimately, he's going to be asking for a new trial. If this gets kicked back down to the trial court and Judge Everett agrees that, there was a constitutional violation, that Rashbaum should not have been representing Charlie, Judge Everett can overturn the conviction and order a new trial, right? He's not going to go free, but he will have another bite of the apple. Whether that trial would be consolidated with anybody else's, I don't know. But he's not going to be walking free, guys. That's, I think, important to remember. Wouldn't he have to use the same defense? I don't think he would be locked into the same defense, but if he doesn't use the same defense, if he comes up with something completely different and he testifies to that, he can certainly be impeached based on his prior testimony. And that wouldn't look good. That wouldn't look good to a jury. I don't know. He would have to get new counsel, just like Donna has to get new counsel. Word on the street is she may have new counsel, but it may not be definite just yet. But he would have to get counsel as well, trial counsel, because Michael Ufferman is appellate counsel. I don't know if Michael Ufferman does any trial court stuff. I don't know. Let's see. Maya's saying, I definitely think that there needs to be a full-blown evidentiary hearing where Charlie puts on evidence about how he came to be represented by Rashbaum. Yeah, because Charlie is rich and educated and he chose Rashbaum as his attorney, knowing that Donna was represented by him. Was he never informed about a possible conflict of interest? Listen, and I said this before, I just think that, the family, he was thick with the family already. And, if he was representing the parents already, they were probably just like, oh, use our attorney. He's the best. I can easily see that happening. Now, whether Rashbaum told him about the conflict, whether Rashbaum knew, I would have to think that Rashbaum knew about the conflict, because my goodness, how are you an attorney and not thinking about that? That's one of the first things that you do when a potential new client comes to you. You have to run a conflicts check. And he's not a solo attorney. He has a firm, so he has resources to do so. And I would also assume that his firm, has a policy in place, procedure for running a conflicts check. I don't know. Their malpractice insurance is probably like cringing right now. That's all I have to say. This is wild. Maya's asking, was he somehow coerced into accepting Rashbaum as his attorney? Coerced, like maybe the parents are like, oh, we'll pay for Rashbaum if you use him, Charlie? Maybe. From some of the phone calls and like the piles of money, remember that? It kind of seems like their money might to some extent be intermingled between the parents and Charlie. So that's possible. This just seems weird to me that Charlie would get a new trial. I get it, but it feels off. I know it definitely doesn't feel right. It doesn't feel right. But let's look at those factors again. So the factors are Meneses, Jefferson, Ferguson, and Libby, those cases. The factors set forth in those establish that relinquishment is appropriate in the instant case. So the first step is the appellate court even relinquishing jurisdiction to the trial court. So that has to be the first step in this whole process before we even get back in front of Judge Everett, and before Judge Everett has to make an opinion about what to do, right? So to establish relinquishment, back to the trial court, they look at whether the appellate proceedings are possibly nearing conclusion. They're not in this case. Whether the conflict claim is frivolous. I wouldn't call this frivolous. It does seem apparent. It does seem actual. It doesn't seem, just like it's just made up. The facts don't seem like a real stretch to me, And it's bolstered, again, by the trial court having said that there was a conflict. So I don't think you could say that the claim is frivolous. The undersigned counsel having an honest belief that there is a credible and good faith basis for Charlie's claim. An honest belief that there's a credible and good faith basis. If you see what Judge Everett did in basically forcing Rashbaum to withdraw, right? If Rashbaum hadn't withdrawn, he would have been kicked off the case by Everett, and then kicking Morris and Commissar off the case. I think that's enough to establish that there's a good faith basis, just based on that act alone. Let's see what else Maya's saying. Then again, it fell off when Rashbaum was representing Charlie. That cross of Wendy was so cringe. It was terrible. It was like I don't know, a rehearsed duet between the two of them. It really, really was. It was really strange watching that back and forth. She was almost finishing his sentences. I remember him asking, I can't remember exactly what it was, but he would say, like, you're pretty educated, right? And she would say, I went to a great school. Or I don't know. I can't think of it right now. But like, she wouldn't answer his question directly, but she would say a supporting fact that was true to support the fact that he just stated. It was really strange, that back and forth. It definitely was not a cross-examination. I remember Shaming of Jay channel saying, Rash, you representing Wendy or Charlie when he was covering Charlie's trial was weird to lawyers and non-lawyers alike. I'm sure it was weird to the jury as well. I think Rashbaum acted like that toward Wendy because he knew it would please Donna, but it wasn't in Charlie's interest. I have to wonder if Charlie asked about that. If Charlie asked Rashbaum about that, you know, because it was a very different dialogue between Rash and Wendy than Rash had with anybody else, you know? So, yeah, I agree. The claim, it can't be said that it's frivolous. Otherwise, you'd be saying that what Judge Everett did, you know, kind of doesn't have any grounds. All right. And let's see. Charlie submits that it serves both the interest of justice. Yeah, obviously, we want people to be constitutionally protected in having fair representation, and judicial economy by having the trial court address his claims at this time. You guys, it's not great news. It's not great news. And I feel bad for the Markells. I really do. I really do. But I don't know. Man, I can't help wondering, like, what is going on in Tallahassee? Has it always been like this? Like, I don't know. I don't know. Anyways, thank you for joining me, you guys. I really appreciate this last minute, you joining me on this last minute stream. I wanted to read through the document because I just saw it and I had been hearing about it for the past 2 days and I couldn't see it uploaded. I don't know if anybody else has read through it yet, but since I wanted to, I figured that I would do it and have you guys join along with me. So now you know the basis of this motion to relinquish jurisdiction. You can more thoroughly, you know, engage in discourse about it, and you know, hopefully, I don't know. We'll keep an eye out. I'll keep an eye out for a response from the state, and or an order from the appellate court on this motion. And we'll go from there. That's all we can do. That's all we can do. All right. So thanks so much. You guys have a good weekend. If you're not busy tonight, join in with myself and Tanika's 2 cents talking about the Sarah Boone trial. tonight at 8 o'clock, I think. We're going to be talking about that. So hit that like button on your way out so more people can see that this was posted. I appreciate you all. Have a good weekend. Bye.